of the NDIS and the Convention on the Rights of Persons with Disabilities. Today we hope to provide you all with another tool and some materials that can assist you in your decision making in reaching the correct or right decision. We will outline how the CRPD is incorporated into the NDIS Act and how this can assist in interpreting the Act and to realise its purpose. I'll give a brief outline of what the CRPD is and what it represents, and how the NDIS fits into the disability reform context in Australia, and how the CRPD has been incorporated into the NDIS Act. I'll also give an outline of what interpretive principles are generally applied to acts which incorporate treaty obligations, and how a purposive approach may assist in the decision-making process. My colleagues will then give 2 case studies on early intervention and social inclusion, and they'll demonstrate that in these contexts, a purposive human rights approach can assist members in reaching the correct or preferable decision. We have a few key recommendations that are the outcome of our research. We propose that members apply a purposive interpretive approach to the NDIS Act by drawing on the origins and the reform context the NDIS operates in, along with the general principles and the articles of the Convention. This approach will then enable children with disabilities to access necessary early intervention supports and services that will enable them to reach their full potential and to participate fully in an inclusive society. It will also allow for a broader understanding of the barriers to social inclusion through focusing on the realistic impact of a person's impairments to their capacity to participate fully in society. So, why are we all here today? The AAT is now tasked with a difficult challenge with its new jurisdiction, the NDIS, as it rolls out across the nation. Members are called upon to step into the shoes of the original decision maker and are invited to substitute or uphold the decision appealed against to reach the correct or preferable decision. But the NDIS is sourced in the disability rights movement and the UN Convention on the Rights of Persons with Disabilities, which is a legally binding international treaty that Australia has signed and ratified, and in doing so has promised to guarantee the rights recognised therein. We recommend that the CRPD be considered in the NDIS decision making because the first object of the NDIS Act is to give effect to the CRPD, and which incorporates the treaty into the Act. There is also express provision in the section 15AB 2D of the Acts Interpretations Act for the consideration or reference to treaties that are referenced within an Act in interpreting it. But how does this affect the process of reaching the correct or preferable decision? In order to determine that, we must first look to the CPRD and what it is and represents. The UN Convention on the Rights of Persons with Disabilities is the first legally binding human rights treaty concerning persons with disabilities. It represents a paradigm shift to empower those with disabilities and recognises them as holders of rights and citizens rather than objects of charity who are victims of their impairments and who are defined by their disability. The definition of disability within the Convention is an inclusive one rather than exclusive one, which allows for flexible interpretation. It is a move away from viewing disability through a medical lens to the social model of disability. Under the social model, disability is the interaction between barriers and individuals. Disability instead arises from the lack of accommodation rather than the individual themselves. For instance, if I didn't have glasses, I couldn't see properly, and I couldn't read, and I couldn't access the materials that are necessary for daily life. But with the lenses, there is no disability. However, in society, bad eyesight is normalised. It's just considered another aspect of human diversity. But this is the approach that we should consider all people with their different capacities. Instead, we should ask, how can they be empowered to participate fully in society on an equal basis with others? This rationale fundamentally underpins the CRPD and was also one of the reasons that the NDIS was chosen as a more appropriate vehicle for managing community supports. rather than the previous ill-suited medical model of care, as explained in the Productivity Commission inquiry that recommended the NDIS. So in the Australian context, we can see how the CPRD operates and how it influences the NDIS through the disability reform context and the purpose of the NDIS. Australia was a leader in the development of the CPRD and contributed substantially to the text. It was also one of the first signatories of the convention. The shift evidenced in the CPRD has informed the direction of the disability reform movement in Australia, and the NDIS is an outcome of this movement. It expressly intends to give effect to the CPRD, and in doing so has incorporated into the Act. The NDIS also operates with the broader disability reform context as part of the National Disability Strategy, which also aims to ensure that the principles of CPRD are incorporated into any policies or programs that come under it, as well as ensure that they're implemented in line with the general principles of the CPRD. Anyone performing functions under the NDIS Act must do so in accordance with these general principles, which, as affirmed by the NDIS Act's Statement of Human Rights, Statement of Compatibility with Human Rights, align closely with the CPRD general principles in Article 3 and the rights identified throughout the Convention. It also states that the placement of the CPRD as the first objective of the Act was designed to promote the status of the CPRD, and it's to emphasise its critical nature in the interpretation of the Act. But how should the CPRD be considered when interpreting the NDIS Act? Australian case law and legislative interpretive principles provide several key guidelines when interpreting treaties that implement when interpreting acts that implement treaty obligations. Firstly, there's a presumption that our laws are to be in compliance with and administered according to Australia's human rights treaty obligations, unless there is an express abrogation or curtailment of those rights specifically, and interpretation of such restrictions is to be narrowly construed. Secondly, this is according to the principle of legality that has been approved by the High Court of Australia, which ensures that fundamental human rights cannot be abrogated or overridden by general language or ambiguity. Parliament must identify what rights and how they are limited with specificity, and it did so with a declaration that permitted substituted decision-making for arrangements when necessary, as a last resort, and subject to safeguards. When it is necessary, though, to interpret the meaning of a provision of the CPRD, the International Law Rules of Treaty Interpretation, Article 31 and 32 apply. Reference to guidelines, general comments and jurisprudence of the UN Committee for the CPRD or other international courts that have construed treaty provisions is also permissible. Finally, we recommend that a purposive approach to interpretation requires the consideration of CPRD. Under the Acts Interpretation Act, Section 15AA1, legislation is to be interpreted in a way which would best achieve the purpose or object of the Act. And this is an inquiry to what mischief the statute was directed at. This mischief was identified in the 2011 Productivity Commission Inquiry Report, Disability Care and Support, which said that disability support in Australia was inequitable, underfunded, fragmented and inefficient, and gives people with disability little choice. It is at these problems that the solution in this instance was the NDIS, which expressly provides as its first objective that it affected the principles of CPRD and was to be implemented consistently with the disability reform context in Australia, which operates as per Section 3.3 of the Act. In the Human Rights Statement of the NDIS, it says that there must be a consistent approach across Australia in the disability reform movement for an integrated, effective and systematic way of delivering the NDIS in accordance with established human rights frameworks laid out in the CPRD. In the first case before the AAT, the President, Justice Brennan, posed 4 questions to be answered in reviewing a decision, including, on the facts and with regard to any policy considerations that ought to be considered, was the decision the correct or preferable decision? We believe that the correct or preferable decision is one which gives effect to the text. And we also recommend that it is necessary in approaching that question to consider the origins and purpose of the Act and its context in the disability reform movement in Australia. And in order to do so, it must be done in accordance with the interpretive principles for incorporated treaties, which considers the merits of a decision under the NDIS through the CPRD, as applicable to Australia and as much as possible. That was my sort of beginning, introduction to the law and sort of the context behind the NDIS and the CPRD. And then my colleague Megan will give us a case study of early intervention and some concrete examples about how we can apply CPRD in those contexts. Thank you for listening.
Thank you.
Thanks, Sarah. My name is Megan Gaffney. As Sarah said, I'm going to speak to you today about early intervention and its relationship to the NDIS and the CRPD. I'm talking about early intervention specifically because it's increasingly recognised as being beneficial for helping children with disabilities to achieve their full potential and participate in society. I know this firsthand. I'll just flag the fact that I'm a parent of a child with autism, so who's now 13. So I'm fully aware on a personal level of how important and vital early intervention is. I mean, we missed the boat because he's a bit older now, but I really am aware of the importance of this and how it can help children and their families. So for that reason, firstly, it's, I think, a really important topic to speak about. But secondly, the CRPD does actually reference early intervention, which you may or may not be aware of. It specifically mentions early intervention. I haven't moved my slides. And so for that reason, it's a really useful practical tool to use in decision making. You can actually lift articles out of it and reference them in your decision making. Even though the NDIS Act itself uses a lot of the language from the CRPD, you can really take comfort in the fact that a lot of phrases and terminology has been lifted directly from the CRPD into the NDIS Act. So when you look to early intervention principles, you can use them both, and they really do both complement each other. So I'm going to speak about early intervention through the study of 2 recent cases that have been decided by the AAT, and I will get to those shortly. So in terms of specific references in the CRPD, you can see that there are 4 articles. Article 25 speaks to provision of early identification and intervention as appropriate. So there, right up, we have a very clear example of early intervention reference. Article 26 tells us that services and programs are to begin at the earliest possible stage. We also need to be mindful to respect the evolving capacities of children with disabilities. I think early intervention does that beautifully. It really helps children evolve and gives them the opportunity to fully realise their potential. And then on a more general level, we have the best interests of the child shall be a primary consideration. And this is something that is also in, that's a family law principle as well, best interests of the child, as you would be aware. So it really is quite broad in its application. So references to early intervention in the NDIS Act, the framework for that, as you can see, couples or combines these elements of supporting through early intervention. People should be supported through early intervention, benefit from the provision of reasonable and necessary supports, provided that the support will be or is likely to be effective and beneficial, having regard to current good practice. So I'm sure that's a phrase that you're all familiar with. I'm going to focus on current good practice because it seems to be, in looking at the decisions that we'll discuss shortly, that this is an area, or this is the definition of this plays a major role in determining whether a support is reasonable and necessary. In the supports for participant rules, it specifies that in deciding whether the support will be or likely to be effective and beneficial, having regard to current good practice, the CEO is to consider the available evidence. In Rule 3.2, evidence may include the lived experience of the participant or their carers, but it must include expert opinion. So it seems to us that this is where there seems to be a bit of the distinction between the social model and the medical model that Sarah was just talking about, because the discretion to include lived experience, it is a more flexible way of applying knowledge. So it really invites the lived experience, first-hand knowledge of the participant or their carers, and it seems to be more in line, we think, with the CRPD principles of the social model of disability. So that's a good thing. It's quite easy to consider that in your decision making. But the obligation to consider evidence and expert opinion, it really seems to suggest a more objective approach, a more medical model is potentially able to be applied here, because we tend to think in terms of prevention and cure, treatments, outcomes, which is sort of what we're trying to move away from, and the whole reason that the NDIS Act was implemented. So in looking to evidence and expert opinion versus lived experience, there seems to be a bit of a tension, we think, between these two elements that need to be considered in the decision-making process. But it is, no, still too early. But the Convention, I'm going to use a few little rhymes today, the Convention can address this tension, because if you're looking at the Convention, you can really look at the, as I said earlier, lifting out certain articles, using certain articles and placing them, referencing them in your decisions, almost like inverting the way you look at the model. So instead of looking at the child with a disability and then whether there's an effective treatment or cure or prevention, we're looking at their ability to participate in society. How is that support or treatment going to facilitate their development and participation in society? So it's really sort of inverting the reasoning process, I guess. So now we get to the autism spectrum disorder consideration, and I'm going to use the case studies because these case studies specifically refer to children with ASD, but also I think it's really important to consider these cases because autism is now so prevalent, and you'd be aware that there's, diagnoses each year are increasing. There are a number of children who are affected by this and will continue to be so, and you'll be the people who are going to be at the coalface of dealing with parents and carers and trying to give them the necessary supports. So I think that the AAT will increasingly be involved in the review of participants' plans and their need for early intervention supports. So the first case I wanted to talk about was TKCW, which related to the provision of a program called the Listening Program. The mother wanted the child to have this program which facilitated, it targeted different frequencies through listening to headphones and different sounds and music on headphones. The frequencies of that would target the vestibular system, which is balance and spatial orientation, speech and language, memory and vision, audition and touch, attention and receptive language. So the expert who was called on by the tribunal didn't know the child, and the evidence was that the listening program, or TLP, was not effective as a treatment for autism. There was evidence from literature reviews that demonstrated the difficulty in measuring outcomes, and that merely collecting anecdotal and testimonial evidence was insufficient to evaluate a beneficial effect. So you can see the language, medical model language really there, treatment, outcomes, evaluate. So the decision not to fund the program was upheld. The concern there is that TLP, the program itself, could be adjusted to different frequencies. So it was really aimed at targeting that child's individual sensory profile and needs. It wasn't just a music on a CD that the child would listen to. It's actually specifically targeting their own needs. I think it was a cost of about $3,000, so it wasn't very cheap, but it was an individualised program that the parents could purchase and then keep and use on an ongoing basis. I think the expert also failed to consider the fact that this particular treatment evidence was given by the people who developed the program, that it increases the capacity to communicate and regulate emotions, which is really important because a child who can't regulate their emotions can't step outside the door and participate meaningfully because they're too wound up, they're too anxious. So something like this, I think, is a really valuable support to have. So that decision, the decision was upheld, not to fund the treatment. However, I'm going to speak just briefly about McCutcheon because Matt's going to mention it later. This was a case to do with an adult participant who had spina bifida and scoliosis. It's a very recent decision, as you would know. They're more encouraging because it takes a broader approach to lived experience, and it was acknowledging that lived experience could be consistent. Where it was consistent with reliable, relevant and independent evidence, it would be given a good deal of weight. So the participant was, the chiropractic treatment was approved because it was seen as a way to facilitate or to maintain her level of pain. She was in a great deal of pain if she didn't have it. So it was her lived experience as it related to expert opinion was given a very balanced view, we feel. So, in having regard to current good practice, we would just suggest that it's preferable to adopt a more inclusive, holistic view of evidence and expert opinion. They're sort of the key terms, I think, to try and view them as friendly terms that you can work with rather than applying outcomes and the treatments and cures to those words. Adopting a social model of disability, asking how particular support may address a child's individual strengths and needs really will help them to participate in society, and that is the fundamental goal of the CRPD. So I think in this way we can turn the obligation to look at expert and evidence opinion into an inquiry. You're acknowledging the impact of the impairment on the child, and also it promotes the purposes of both the NDIS Act and the CRPD. So on a practical level, what articles can we look at? So Article 26, if you were to apply that, for example, to the obligation to consider expert opinion, TKCW was the listening program. So we could have perhaps asked, is there evidence that the expert, in this case, has considered the individual needs and strengths of the child such that a particular service or program will help them enable a child to participate fully in all aspects of life? That is something that, as you can see, the bold parts in bold come directly from Article 26. So you can really just look at, on a practical level at Article 26 and say, right, I can really reference that. It's extremely relevant in this case. Similarly with ZNDV, which if you were going to look at the the discretion to consider the lived experience of the child, you look to Article 25. You say, how might the support, or you ask, how might the support minimise or prevent further disabilities, and what benefits might flow from the provision of a particular service or program within the child's own community. And I think that's a really important point regarding community, because in this case, the mother was proposing that the OT room, occupational therapy room, be at home. And she wanted to set up a room in the garage so that he could be in his own environment, and she could go out there with him, and doing this would minimise his meltdowns and his shutdowns, and in our opinion, very conducive way of facilitating a child's connection with the community, because they're able to have that OT experience, if you like, as often as they need it, which is going to make them calmer, it's going to make them more amenable to socially interacting with other children, and there again underlies the purpose of the CRPD. In saying that though, we don't know if this approach had been applied in these decisions, if it would be any different, and we don't suggest that this would have certainly made a difference in the outcome. We're just simply suggesting that this is a way that could have, the decision may have been approached in an alternative way. I also just briefly want to mention Article 3, which is evolving capacities. Could also be applied to current good practice, because ASD being characterised by the impaired ability to socially interact and regulate behaviour means that a child's capacity to do that is evolving. But this is not restricted to just children with ASD, obviously. All children have evolving capacities, and Article 3 speaks to that beautifully, I think, because it says that therapies and programs that aim to develop a sense of self and preserve identities are to be encouraged and supported. And finally, Article 7, which I haven't made a big heading there, but it's very, again, it's very important. In the event where evidence would be ambiguous, or where the expert opinion fails to address the impact of impairment on functioning, if you're not quite sure how to use the expert opinion, you can really just look to this article, because it's really appropriate and important to foreground the welfare of the child generally. So we can say that, look to Article 7, which says that in all actions concerning children with disabilities, the best interests of the child shall be a primary consideration. And just finally, to finish with another rhyme, I would like to encourage you to look to the Convention for Early Intervention, Articles 3, 7, 25 and 26. So thank you so much for your attention, and I'm going to introduce Matt, who's going to conclude our presentation today.
Thanks, Megan. Good afternoon, everybody. My name is Matt Peary, and I'll be presenting the third and final part of our presentation today. I'm also very aware that I'm the last thing between you and the wine and cheese behind you, so we'll try and be brief. Regardless, I think I'd like to talk about something particularly important, especially given the context with which we've discussed the NDIS today, and that is social inclusion and the NDIS, social inclusion for persons with disabilities. And in particular, I'd like to talk about how we can apply the NDIS legislation in a way that can help achieve this greater purpose, to achieve not only social inclusion, but fuller and more effective social inclusion for persons with disabilities. As Sarah has spoken to briefly recap, the NDIS was implemented as part of a broader paradigm shift in the treatment and perception of persons with disabilities in Australia. And part of that was to apply the Convention for Persons with Rights, or Rights of Persons with Disabilities in Australia. As we've noted, a fundamental impetus of the Convention was to shift from a medical model of disability to a social model. And by shifting to a social model where the interaction between a person's impairment and society more broadly becomes the focus of the inquiry, it's necessarily the case that achieving greater and more effective social inclusion is a fundamental aim of that model. And we believe this flows through the CRPD into the NDIS, and therefore it colours every element of the Act in and of itself. So we can look to the Convention in particular. We find, as I've noted, that by reflecting this social model of disability, the Convention embodies this fundamental purpose of achieving fuller and more effective social inclusion for people with disabilities. But in particular, the CRPD articulates rights and duties that obliges the state's parties to implement this purpose. And as we've noted, and I'll get to it in a moment, but the NDIS, its first object is to actually implement those obligations which Australia has ratified in a domestic setting. But if we look through the CRPD in particular, we find references to social inclusion explicitly throughout. The first two come from the Preamble and Article 3. The Preamble notes that attitudinal and environmental barriers can hinder the full and effective participation of persons with disabilities in society, while Article 3 provides a general principle to the Convention itself and notes that one of its objects is to achieve the full and effective participation and inclusion. So these two collectively colour the entire Convention themselves. But we note that Article 19 provides a more substantive provision which imposes obligations on state parties to undertake effective and appropriate measures in the domestic sphere. And the final article we think is relevant is Article 8, which notes that the state's parties are obliged to promote positive perceptions and greater social awareness of persons with disabilities. And what we think is that this indicates that the barriers to social inclusion which need to be addressed by the CRPD and indeed by the NDIS are broader than simply what the impairment may constitute for a person. They take into account intangible things such as stigma or negative stereotypes or embarrassment. And I'll work through some of these in examples of AAT decisions which have been handed down so far. But this is the context in which we operate, and as we know, two slides. There are technical difficulties, but I'll just go back. Oh no, this is the slide I want. I'm not as good as Brian made me out to be.
Still better than me.
In any case, we note that this flows through to the NDIS not only in its broader context, but it's littered throughout. There are references throughout the entire legislative scheme to achieving social inclusion. Firstly, it appears in the object section. The first object of the NDIS is to achieve the obligations of the Convention, but its other objects explicitly note that it's to support the independence of persons with disabilities, to achieve social and economic participation, to raise community awareness, and to facilitate greater community inclusion. This flows through to Section 4, which provides for guiding principles for any action taken under the NDIS. In particular, it's to support their ability to participate and contribute, and this is where it departs a little bit from the Convention, to social and economic participation. And economic participation is also particularly important here, because in a practical sense, what it flows through is to often the ability to work, the ability to engage in society in that capacity. And I'll mention that later on in one of our case studies. It's also targeted in a more substantive sense to the assessment of what is a reasonable and necessary support, and making sure that what is determined to be a reasonable and necessary support looks to how those supports can achieve fuller and more effective social inclusion. I should note it's not up there, but also in Section 24 of the Act, which discusses who is eligible to become a participant of the NDIS, it makes explicit reference in Section 24(1)(d) to how that person's impairment affects their social inclusion. So the purpose of achieving greater and fuller social inclusion for persons with disabilities is not only a broad overarching principle, but actually plays into the substantive assessments of both the assessment criteria for participants and what are reasonable and necessary supports for those participants. Before I get into the case studies and articulate how we think a propositive approach might be applied to achieve this goal, these are the four general principles which I think we can take away from the consideration of social inclusion and the NDIS. The first is, as I said, to apply a propositive interpretation to every part of the NDIS legislative scheme to achieve a fuller and more effective inclusion and participation for persons with disabilities. And it's important there to note that it is a full and effective social inclusion. The second way, or the way in which this can be achieved, we recommend, is that it is to adopt a broader understanding of what are the barriers to that social inclusion, and to shift our focus away from simply the physical or mental or sensory impairment itself, and to look at how that impairment interacts or impacts on that person's ability to interact in society. This will necessarily require, we suggest, a focus on societal attitudes and environments, not simply, as I mentioned, the physical impairment, which is often, and for good, for obvious reasons, the clear focus. And finally, as I mentioned just briefly before, it's important to apply this propositive interpretation to not only the assessment of the participants who becomes a member of the NDIS, but also to what reasonable supports are given to them. And that's to make sure that we don't arbitrarily exclude persons who otherwise would be the beneficiaries of the NDIS, and indeed who should be the beneficiaries of the NDIS given its purpose to shift the perception of disabilities in Australia. We need to not only identify people who face those broader intangible barriers to social inclusion, but then work out how we can provide supports to help them break those barriers down. So I'll move on to some case studies now, which I think will hopefully provide some tangible examples of how we can apply the NDIS legislation to achieve this goal. But I would like to start by saying a few things. The first is that, as Megan noted, we're not here to say that the outcome should have been different, or that the outcome would necessarily have resulted in X, Y, Z if these things had been done. What we're focusing on is the process of reasoning behind them. And in particular, we suggest that there are certain instances where the interpretation of a provision or of a word or a section of the Act might have been conceptualised in a different way. And were it conceptualised in a different way, that would be more consistent with what we submit is the purpose of the NDIS. Of course, the outcomes may result in the same thing in the end, but it's about that reasoning process, given that the NDIS is intended to reflect a shift in perception of disabilities in Australia that we think is important. The second part is that the case is often turned on sections which I will not be focusing on today. And that just goes to further illustrate the point that it's not necessarily about the outcome, but it's about the process of applying the Act in what we consider to be the most consistent with its purpose and the convention. So the first case we'll look to is the case of Mulligan, which was decided middle of 2014. Mr. Mulligan suffered from chronic ischemic heart disease, from cardiomyopathy, from sciatica, from 2 ruptured discs, and as a result of that he suffered generally consistent back pain and also found it very difficult to physically exert himself. For some examples, Mr. Mulligan could not really walk more than 100 metres on flat ground or 50 metres in the incline before needing to take a significant break because of his physical exertion. He also found it difficult to manage general self-care tasks and things like that because of the pain of his impairments. Further to that, he suffered from serious panic attacks and had been hospitalised roughly 15 to 20 times previously. And this fear of panic attacks meant he lived a more restricted social life. He was unable to go outside and see his friends as often as he would, and that impacted on his mental health. It's in this context that the Tribunal was asked to consider whether or not he satisfied the disability requirements to become a participant of the NDIS. And in particular, the case turned on the assessment of section 24(1)(c), which looked to whether or not Mr. Mulligan's functional capacity was significantly reduced, substantially reduced, with respect to certain key criteria. A couple of those criteria were his mobility, his self-care, and his social interaction. The outcome of the case was that Mr. Mulligan was not found to be a participant of the NDIS. His function in those areas was found to be undoubtedly reduced, but not substantially reduced. And in particular, to quote from the reasons, the Tribunal found that he was effectively, if not efficiently, able to participate in his mobility and his self-care. On a reading of the Tribunal's reasons, it's not explicit what exactly constitutes that effective or that efficient assessment of mobility. But we suggest that the Tribunal's interpretation of the legislation is in fact more consistent with the previous medical model of disability. By the most reasonable assessment, a person who cannot walk more than 100 metres at a time, to find that they were effectively mobile, we submit means that was founded on the fact that he was individually mobile. He could get around by himself, but with difficulty. And therefore the inquiry necessarily focused on the fact of performance rather than the manner. This inquiry focused on how to cure his impairment rather than how his impairment factually impacted his ability to interact in society. And so we submit that this inquiry here fails to reflect the social model of disability, which in and of itself asks the decision makers to look beyond the physical impairment to how it factually, in reality, would affect the person's ability to interact in society. And in this context, we'll not go to the next slide. Thanks. I might just take this one. It's in this context that we find that three recommendations arise. The first is to apply this propositive interpretation, in particular to section 24. And in order to do so, we can ask whether the participant's capacity to participate in society is substantially reduced in fact rather than theory. And that's a focus on the factual result of the impairment, and it requires looking at the manner in which the person is able to perform the criteria of section 24(1)(c). So it's not looking at the fact that the person is mobile, but considering the manner in which they are mobile. We suggest that this would reflect the social model of disability and ensure that the NDIS therefore implements its broader purpose. And to do so would require a broader understanding of what those barriers to social interaction are. Acknowledging that, for instance, having to stop after every 100 metres would necessarily make it more difficult for somebody to interact with their friends or to go out in a social environment or to enjoy being outside in a social environment. And thirdly, we would submit that it's important to maintain the distinction between focusing on the impairment and its factual impact on the person's operation in society, and not to confuse the two by simply focusing on the impairment itself. And this is supported both by the text and structure of the NDIS legislation. Indeed, section 24(1)(c) separates out that distinction by making sure the focus is on what is the impact of the impairment rather than what is the impairment itself. And this was indeed affirmed by Justice Mortimer in the Federal Court on Appeal, who noted that the statute requires the decision maker to look, as a matter of factual assessment, to the outcome of the person's impairment on the performance of the activities listed in section 24(1)(c). And so it's in this context that we submit a propositive approach to the NDIS legislation would have been able to better reflect the social model of disability through the NDIS Act. Our second case study looks at the second part, or the second main purpose really of the NDIS, which is to provide reasonable and necessary supports. And it's the case of Young and the NDIA, which was again decided in mid-2014. In this case, Mr. Young had emphysema and also type 1 diabetes. Mr. Young's emphysema meant that he required an oxygen pump, which he carried around in a trolley behind him. The oxygen pump and trolley, in total weight around 9 kilos, was rather large and made it difficult, was rather awkward to port around. The type 1 diabetes meant Mr. Young needed to inject himself with insulin on a regular basis. But he had recently moved to an insulin pump which automatically was more convenient and meant he didn't have to do it in public because it took care of itself. Mr. Young came to the NDIA to ask for support to purchase a smaller and more portable oxygen supply, and also for funding for his insulin pump, which had ceased with the end of his private health insurance. The case then turned on whether the supports were appropriate for the NDIS to fund. And in considering whether or not they were appropriate for the NDIS to fund, the Tribunal looked to section 7.4 of the rules for reasonable and necessary supports, which in and of itself required an inquiry as to whether these supports would enable the participant to undertake these daily activities. On the reading of the Tribunal's reasons, we find that the inquiry of enable, or the interpretation of enable, was applied rather narrowly. And the Tribunal found that the supports would not enable Mr. Young to undertake these activities, because without them he was not unable to undertake these activities. And in that sense, the tribunal found that his previous means of taking care of himself, the non-automatic insulin pump and the larger oxygen tank, were sufficient to enable him to undertake these activities. So again, we find that here, the tribunal's reasoning appears to have applied a more medical model of approach. It seems to focus on what was reasonable and necessary to cure his impairment, what was reasonable and necessary to allow him to breathe and to allow him to manage his type 1 diabetes. What we suggest, though, is that a more consistent social model approach would have looked to what was reasonable and necessary to help him break down those barriers to social inclusion. Mr. Young's current way of maintaining his condition left him embarrassed to go outside. It left him facing difficulty to port his oxygen tank, and it left him unable to attend the gym and other activities such as driving easily. We suggest that that adoption of the more convenient and more portable supports here would have helped him to break down these barriers by facilitating that greater social inclusion. It would have reduced his embarrassment, it would have meant he was able to move around more freely, and therefore to engage in more meaningful social interaction. And to ignore those factors, we think, constitutes a rejection of those legitimate attitudinal barriers to persons with disabilities engaging in society. And it's in that context that we find 3 recommendations again, applying a purposive interpretation to ask whether supports will in fact, rather than theory, assist that participant to engage with society. Reflecting a social model of disability by making sure those reasonable supports target the barriers to social inclusion rather than curing the impairment themselves alone. And practically, to do this, we suggest that a broader interpretation of assist, value for money, and effective and beneficial, considered in this context, would help the tribunal to apply these decisions. Now, I appreciate that in this context, and this is one where particularly we say, the outcome may not have been different. To find that the reasonable necessary supports for a more portable oxygen tank is not necessarily the outcome of adopting this reasoning. But I would give you an example of my own self to illustrate why I think this is an important shift in the reasoning. When I came into the building, Brian very kindly opened 2 doors for me. You can tell I'm obviously a very large fellow. But behind that, aside from being a gentleman, was the understanding that often the building is not set up for people with disabilities, for persons in wheelchairs. I use a wheelchair to help overcome an impairment, at least in one sense, and that's mobility. It means I'm able to move independently. But that's in the most basic of senses. More broadly, I use my wheelchair to get into rooms, to get onto tables, to go up and down curbs, to get into my car and drive around. And so therefore, the manner in which I use my wheelchair is not merely a consideration of convenience or ease of use. It's fundamentally linked to my ability to engage meaningfully in society. And I know that because I didn't always have a conveniently small wheelchair. In the early days, I used to have a very large one, a very heavy one which would not have fit through that door or onto that table or into my car. And that impacted how I was able to engage with society. It meant for the most part I was not able to engage with society. And so what we suggest here is that applying the NDIS legislation in this way is not merely about making things easier for people. It's not about preference or convenience. What it is about making sure that the reasonable and necessary supports focus on how that participant can meaningfully, fully and effectively engage in society. And therefore we think it's important. To finish on a promising note, a recent decision was handed down by the tribunal in McCutcheon only a few months ago, under a month ago. And in this case, we noted that the tribunal applied a broader recognition of the social barriers to engaging in society for persons with disabilities. As Megan has alluded to, McCutcheon was a case where a lady suffering from scoliosis and spina bifida sought funding for chiropractic treatment. To run through the facts very quickly, the chiropractic treatment was found to basically reduce her pain and to increase her mobility, but increase her mobility in the sense of maintaining her function. It did not provide any substantive improvement to her impairment. it did not actually make her any less susceptible to the symptoms of spina bifida. It only made that she was able to maintain her function and manage them more consistently. This was illustrated by when she stopped chiropractic treatment, her condition deteriorated, but when she had it, it didn't necessarily improve. Nevertheless, the tribunal found, in considering whether or not these supports should have been provided by the NDIS, they inquired as to whether it was effective and beneficial treatment. And it found that it was, because the reduction in pain resulted in a practical ability for McCutcheon to be able to engage more fully and effectively with society. In particular, the tribunal noted that the reduction of pain was integral to her ability to live in the community, to have a social life, to continue her studies, and to re-engage her employment. And that goes back to the point of economic participation mentioned earlier. And this illustrates a broader understanding of what those barriers to society are. It's looking beyond the pure impairment itself and noting that the way it impacts a person's ability to engage in society is what really the NDIS is supposed to address. And so this application of the Act by the Tribunal, we suggest, is spot on with the social model of disability, and so therefore, good job, everybody. A final point is to say that because it's a purposive approach, what we submit is that the reasoning process we've outlined today is not necessarily limited to one or two sections, but can be applied more broadly across the Act in its entirety. The following sections, however, though, we suggest are probably the easiest and the most beneficial to apply that interpretation. And in doing so, we would suggest that the bolded words are ones for which an interpretation should be given, again, as we've discussed, in the context of achieving that meaningful social interaction. And so to take one example there, the first one, section 411C, to develop and support the capacity to undertake activities. In the consideration of what the person's capacity would be, it would be important to consider not only their impairment, which might be physical, but also how that impairment results in their psychological state. And that's whether they're afflicted by embarrassment or suffer from stigma or other negative stereotypes in society. Because that will, while not being explicitly linked, the impairment itself, links to the impairment and affects how the impairment enables that person to participate in society. And therefore that broader understanding of what the barriers to social inclusion are, not simply the impairment, but the impairment's impact on that person, is fundamental to ensuring this purposive approach is applied. To quickly rehash our key recommendations, we suggest a purposive interpretation to the NDIS Act can be achieved by drawing on the principles in the Convention on the Rights of Persons with Disabilities. And in doing so, we suggest providing early intervention supports and services for children with disabilities in order to enable them to reach their full potential and participate in inclusive society is one fundamental tenet of it. And the second is that it's important to apply a broader understanding of barriers to social inclusion by focusing on the factual impact of a person's impairment on their capacity to participate in society. Thank you very much for listening to us today. If there are any questions, we would love to answer them. Both Sarah, Megan and myself are happy to answer questions on any parts of the presentation. But thanks a lot for coming. We appreciate you taking the time, and we really hope that this might help the AAT and its members in their future decision making, which is no doubt a very difficult environment that you operate. Thank you.